It seems like nearly every day when we look at the news, we see a new push by America haters to force the rest of us to embrace the radical gender ideology that they want to impose on Indiana and the rest of the country. Literally just yesterday, my office, along with 5 other states, had to sue the U.S. Department of Education to protect the rights of our Hoosier women and girls from President Biden's insane rewrite of Title IX that would allow biological men to invade women's sports and locker rooms like they have already tried to do across the country. Title IX was meant to protect women and girls, to nurture their endeavors, not destroy them like the left is doing today. Unfortunately, it's affecting everyone, including small businesses worried about getting caught in a lawsuit surrounding these types of issues. So today we are here to announce a formal opinion, this time regarding the use of preferred pronouns in the workplace. Sometimes legal issues can be incredibly complex. They can be a web of conflicting rules and interpretations, and our office deals with those every day, and we deal with them well. But honestly, this is not one of those issues. Instead, it's very simple. There are, in fact, 2 sexes, and only 2 sexes, male and female. The fact is, we cannot function effectively as a republic if we deny the basic facts of creation. So in light of this basic scientific fact, the questions for employers and fellow employees become, does any law require you to refer to another coworker by their preferred pronouns or a different name? Could you as a business owner be found liable if you or your coworker refuses to do this? In the times we live in now, these are important questions. And so I would like to thank my friend, Representative Mike Speedy, who is here and will be speaking on this issue in just a few minutes, for bringing attention to this topic and requesting this opinion from our office. And that's because as I travel the state, I personally speak with many small business owners on a daily basis and their employees. And everyone's concerned about the transanity that's dominating so many facets of our society. In this economy and with the inflation we are all dealing with, they are also having to worry about potentially spending time in court and wasting money on expensive lawyers to defend themselves over this issue instead of simply making a return on investment in their products and services and effectively providing for their communities and their families. So in response to Representative Speedy's questions, our opinion plainly clarifies that neither state nor federal law requires a coworker to use the preferred pronouns and names of fellow employees. It's that simple. Because of this, an employer or small business owner is likely not liable in cases where their staff members choose not to adhere to it either. Our opinion also makes clear that no federal court has ever found that if a coworker uses a non-preferred pronouns alone, even if intentional, that's actionable discrimination under Title VII. However, it is possible in certain situations, albeit rare, that repeated, continuous, intentional use of people's non-preferred pronouns meant only to harass someone could create a hostile work environment under the right, again, rare circumstances. So we can't say there's absolute immunity, and one should be mindful of whether such conduct goes over the line under Title VII. Look, most Hoosiers agree that we all should extend love and compassion toward individuals dealing with gender dysphoria. After all, it is a problem, and it should be treated, but it doesn't need to be affirmed, nor should it. Treating these individuals with respect, however, does not require us by law to deny basic truths, like the fact that there are only 2 sexes, and that an individual is one of them. With that, I will step aside and let Representative Mike Speedy explain why he requested this opinion. Then we will have Bill Anthony, a great member of my team and leader of our advisory division, and part of the team who led the writing of this formal opinion, come up and give us more details about it. Thank you very much for your attention. Representative Speedy.
Thank you, Tim. Thank you, Attorney General Rokita, for issuing this opinion, inviting me here today to say a few words. I wanted to tell you how I came about requesting this opinion. In my tenure as a state representative, I've always been a champion for small business. I've supported the reduction of business personal property taxes, corporate income taxes, individual income taxes, and I've also fought for small business when it comes to an agency here in the state abusing their authority or the ambiguity in the law, and we've used proactive pro-business legislation to put them back within the confines of the law, and allows that a business to grow and prosper. So having done that for many years, I developed a reputation of being a go-to person for small business, and I've had the privilege to tour a lot of these businesses around central Indiana and Indianapolis. And during those tours, the employer, the owner, and the employees would express to them what type of challenges they're facing in the workplace. Could be regulatory, but in this case, it's obviously more cultural, and it's very concerning that this could be happening potentially in their workplaces, people being forced to use pronouns that violate their conscience, or names that don't make sense as well. And so I've had these conversations with small business owners, and I wondered where the law stood on this. And then that's when I got in touch with Attorney General Rokita, and thankfully his office went to work and have prepared this very concise, very well-documented opinion that allows a measure of protection and comfort, if you will, for people to be themselves, as long as they are loving and respectful, but to allow them to be who they are in terms of their faith and their conscience. And I appreciate that document allowing that small measure to all the small businesses throughout Indiana. I want to applaud Todd and his office for joining so many lawsuits to push back on the federal government, like the EEOC guidance document that required a court opinion a couple of years ago to protect Indiana, to enjoin it, as they say. Todd's office was one of several states, over a dozen or so, that joined that lawsuit, and that's what a good public servant does, is push back on these very, what I call ultra-liberal, some would say woke, federal agencies, and push back and protect Hoosiers with their actions. I applaud Todd and his office for doing that in Title IX yesterday, and it's part of my job as a state representative to do the same. And I appreciate, that's why I'm so appreciative of Attorney General Rokita's office, him, and this opinion. Thank you again for inviting me here today and to give a few remarks, and I appreciate it very much.
Yeah.
Thank you.
Thank you, Representative Speedy. Appreciate your leadership on this issue. And now, as I indicated, Mr. Bill Anthony, the leader of our advisory division, will go through the opinion in a little bit more detail for you all. Bill?
Thank you, General Rokita and Representative Speedy. Good afternoon. My name is Bill Anthony, and I serve as Chief Counsel of the Advisory Division within the Office of the Attorney General. This opinion of the Attorney General today clarifies some important points of law. The questions presented are as follows. Does state or federal law require an employee to refer to a coworker by their preferred pronouns? And two, is an employer liable to an employee if a coworker or customer or client of the employer refuses to refer to the employee by their preferred pronouns and new name? In short, neither state nor federal law require a coworker to use the preferred pronouns and name of a fellow employee, and therefore an employer is likely not liable for such conduct if a reasonable person would not find the work environment to be objectively hostile. Bostock v. Clayton County, Georgia, is a set of cases that have provided the most recent guidance on Title VII and discrimination against an individual because of sex. Bostock's holding was limited only to the practice of firing an individual because of an employee's sexual orientation or transgender status, and did not opine on other types of conduct. Additionally, the Indiana Civil Rights Act does not include sexual orientation, gender identity, or transgender status as protected characteristics as applied to sex. Therefore, while Bostock's limited holding applies to Indiana and its employers covered under Title VII, the Indiana Civil Rights Act does not provide any additional protection to individuals based on gender identity or transgender status. Guidance issued by the Equal Employment Opportunity Commission in 2021, which attempted to expand the holding of Bostock and explain employers' obligations with respect to dress codes, bathrooms, locker rooms, showers, and use of preferred pronouns or names, has been found now by 2 federal district courts to be an improper expansion of Bostock, in that it places unenforceable duties on employers. Therefore, any reliance on the guidance would be in error, as it does not possess the force of law and is not an accurate interpretation of the law. Importantly, no federal court has found occasional use of pronouns consistent with biological sex, rather than use of preferred pronouns, even if intentional, to constitute actionable discrimination or create a hostile work environment under Title VII. Title VII sex discrimination claims can be alleged either through alleging discrimination because of sex or by alleging that conditions of employment created a hostile work environment. In a typical discrimination case, a plaintiff must carry the initial burden and can establish a prima facie case by demonstrating that 1, they are a member of a protected group, 2, they suffered an adverse employment action, 3, the performance of their job duties met the employer's legitimate expectations at the time of such action, and 4, the position remained open or was filled by similarly qualified applicants outside of the protected class. Another type of Title VII claim is that of a hostile work environment. A hostile work environment exists when a workplace is permeated with discriminatory conduct that is sufficiently severe or pervasive to alter the conditions of the victim's employment and create an abusive work environment and is imputable to the employer. Determining whether a workplace is hostile or abusive will be fact-specific, nuanced, and will require looking at all the circumstances. Bear in mind, however, Title VII does not establish a general civility code that would prohibit all teasing and offhand comments. Isolated incidents, unless extremely serious, will not amount to discriminatory changes in the terms and conditions of employment. In summary, neither state nor federal law require a coworker to use the preferred pronouns and name of a fellow employee. Although such conduct will not likely create a discrimination claim under state or federal law, employers should be mindful of whether repeated conduct, in addition to other circumstances, may be an actionable hostile work environment claim under Title VII, as that area of the law is unsettled at the moment. With that, I'll yield and turn it back over. Thank you.
Thank you, Bill. Thank you, Bill. I appreciate that. And now Representative Speedy and I will stand for any questions that the audience has.
So the first question here coming from Facebook is, why is this topic an issue for you? This item is a matter of personal choice and individual freedom, is it not?
I'll turn this over to Representative Speedy shortly, but it's not necessarily about the person, it's about the other employees that that person works with. And we have to ensure that we have a workplace that's non-hostile to everyone. And what we found in the law here is that there is no requirement, at the end of the day, there's no requirement that an employer or other employees have to address by pronoun a certain employee because that's their request. The fact of the matter, like I said earlier, there are two sexes, male and female, and you are allowed to address a fellow employee by that given sex.
I don't believe this opinion in any way infringes on anyone's right to be who they think they are. What it does is it protects employers and employees from that ideology from being imposed upon them in a workplace environment, and that's fair to everyone. And that's why, I applaud this opinion.
So Sandra emailed in a question earlier today. She says, why are you giving this subject any media attention at all? We keep addressing this, and it will continue to be around.
So one of the core functions of our office is to issue these types of opinions. We particularly do these for legislators upon request. And they come in various forms, and one of those forms is a formal opinion. Because Representative Speedy's good questions have far-reaching implication and usefulness to employers across the state, we felt it important to be able to make sure that this opinion was published. And the way we do things in this office, as you've seen since my administration, is that we take the news right to the people through or around the media, depending on how the case may be. But that's the reason we're doing this today. There's 6,000 opinions on our website.
I too wish that we weren't talking about this. I too wish we weren't here, but we are here because of where we are in this culture, in this country, the state, and it's our jobs as public servants to be responsive to our constituents and to protect them or provide them some measure of protection. And that's that was my motivation, and that's the purpose of this opinion.
So you kind of just answered that, but this is from Brittany Carloni, Indy Star. She says, is the AG aware that Rep. Speedy and Rep. Zay are running in highly contested GOP primaries this upcoming Tuesday? Do you have any concerns about these announcements coming before the primary and potentially appearing as political activity?
I'll take that one. No, this is our job. Like I said, there's 6,000 opinions on our website. And this opinion, in fact, I believe was asked for months ago. In fact, Representative Speedy, my apologies. We've been so busy, we're a little bit behind, but it's been months. And so we get these as soon as they're ripe and ready to be published, and only after they're fully researched. When that comes in a political calendar is really irrelevant, but this office will keep doing its job.
What conduct would you constitute as a hostile work environment under Title VII? I think we hit on all that, but if you want to go over it, maybe Bill wants to go over that one more time. But
well, what's the question?
What conduct would constitute a hostile work environment under Title VII if there is no law preventing coworkers from intentionally using non-preferred pronouns?
If there was no law, go slow.
If there was no law preventing coworkers from intentionally using non-preferred pronouns.
Yeah, that's just going to be a case-by-case basis kind of situation. There's no way to with any practicality, to go into that kind of detail. The bottom line is that referring to someone by their what their pronoun should be based on science, and repeatedly doing that in and of itself is no violation of Title VII under either federal law or state law. So the idea of harassment generally in terms of employment means it has to be pervasive, severe, obviously intentional, but just referring to someone by the pronoun of the sex that they clearly are is no violation.
That's all the questions I have. I don't know if you guys want to say anything more to close.
I'll let Representative Speedy close this out, but just want to thank everyone for their attention. We appreciate everyone's support for your Attorney General's office, and I appreciate the great employees and staff that we have here at the office. And Representative Speedy?
Thank you again, Attorney General Rokita and his office for issuing this opinion. Again, this is the motivation here is to protect businesses from government overreach, from cultural, the cancel culture, the wokeism that we are experiencing. We are simply being responsive to small business in asking for this opinion, and allows people of either traditional or a faithful perspective to be who they are if they're if they continue to be loving and respectful, but not have to bow down to our woke culture. And again, I just thank you for issuing this, and I'm glad you invited me to this press conference. Thank you.